What rights does a patent owner have in Sri Lanka? How long does patent protection last? Can someone use a patented invention without permission? In this video, we explain the key aspects of the Intellectual Property Act No. 36 of 2003 relating to patent duration and owner rights. We will cover patent duration, owner rights, infringement, compulsory licensing, and prior user rights under Sri Lankan law. Our focus is specifically on Chapters 14 and 15 of the Intellectual Property Act No. 36 of 2003. Let's begin with the duration of a patent, as stipulated in Section 83 of the Act. According to Section 83(1), a patent in Sri Lanka expires 20 years after the filing date of the application. For example, a 2025 filing lasts until 2045. Section 83(2) requires annual renewal fees to keep the patent active. Failure to pay these fees, even with a 6-month grace period, means the patent may lapse before the 20-year period ends. Moving on to Section 84. This is where the Act grants the core exclusive rights to the patent owner. These rights include exploiting the invention commercially, assigning or transferring the patent entirely, and licensing the patent to others in exchange for royalties. Crucially, no person can commercially use the patented invention, whether making, selling, or importing it, without the explicit permission of the patent owner. Section 84(3) defines exploitation broadly, which clarifies what constitutes infringement. For patented products, exploitation encompasses making, importing, selling, exporting, or simply using the product. Unauthorized acts in any of these areas may amount to infringement. Section 85 creates a special rule for process patents. If a patented process yields a new product, the alleged infringer must prove the product was made using a different method. Patent rights are not absolute. Section 86 sets forth important exceptions that limit the exclusive rights of the owner. One exception is the scientific research exemption, which generally allows the use of a patented invention for academic or non-commercial research purposes. The exhaustion principle applies once a patented product is legally sold. The owner loses control over its future resale. If you buy a patented smartphone, you can resell it. The Act also addresses compulsory licensing and the protection of prior users. In special situations like national emergencies or public health crises, the Director General may authorize use of a patent without the owner's consent, ensuring public access, while the owner still receives reasonable compensation. Section 87 protects those already using an invention in good faith before the patent application was filed, allowing them to continue their prior use. These provisions ultimately balance the rights and incentives of inventors with the broader public interest and needs of society. The Intellectual Property Act provides robust patent protection for 20 years and grants the inventor exclusive commercial rights backed by legal action against infringement. Remember the important exceptions for scientific research, the exhaustion principle, compulsory licensing in emergencies, and the protection afforded to prior users. Thank you for watching.